I can't say that I knew the prominent real estate developer Samuel Hakimian. However, I do think it's fair to assume that one of the goals that he had when he set up his estate plan was that this substantial estate was not going to be in the public eye. The fact that we're going to discuss what happened today tells you that the effort failed. If he was successful, no one, including me, would know much about the dispute involving his sons and his attorney. I'm Jay McDaniel. This is Closely Held. Today we'll be talking about what steps people take to keep an estate private and to keep their financial affairs out of the public eye. It's important to many successful people in business that their financial affairs remain private. I'm a lawyer at the Weiner Law Group. I represent primarily small business owners. And today we'll be discussing what steps you might take in setting up an estate to keep your private financial affairs private. More particularly, whether you can compel the people who are the beneficiaries of your will to use private arbitration and to keep any disputes out of the public eye. Please take a second to subscribe, to like, or to share this video. Now, I've focused my practice on fiduciary litigation, including estates, trusts, and closely held businesses. If you have additional questions or would like to reach out to me, you'll find my contact information in the links below the video. Now, our starting point for this discussion is a case involving the substantial estate of a well-known developer in northern New Jersey. He died in 2018. His will required that any beneficiaries that had an issue with his estate must resolve that dispute through private arbitration. Did it work? No, not exactly. Let's take a look at how the arbitration clause failed to keep the matter out of the public eye. We'll examine the events surrounding the Hakimian will and look at some possible alternatives toward the end of the video. Many people like the idea of arbitration. They contend it's more efficient, faster, and that the proceedings are private. I'm not such a big fan myself, but whatever may be my misgivings, I will agree that arbitration is private, and what goes on in a private arbitration generally is between the parties only. Probate, on the other hand, is a public process. Hakimian had two sons, Peter and Richard. He also had a family attorney and friend, Edward Imperator. Hakimian's will set up several trusts and named his son Peter and Imperator as the co-executors. His son Richard, however, was unhappy with the way the estate was unfolding, and he filed an action in the Chancery Court to compel an accounting of the estate. Richard and the attorney Imperator sought to dismiss the case and to compel private arbitration. There are other approaches that planners use to avoid publicity. One is to avoid probate entirely. What does that mean? It means, in essence, that you give away as much of your property as possible while you're still alive. You can do it through a few different techniques. One of the more common techniques is to create a trust that becomes the owner of all your property. Then, when you die, the trust passes directly to the beneficiaries outside the probate process. However, one of the drawbacks there is that trusts are still part of public proceedings. If there's a dispute over the trust, it ends up in a public court proceeding. The other way is through joint ownership of properties with the right of survivorship. Joint ownership with the right of survivorship transfers the property at the time of death, outside of probate. Now, the big drawback to the trusts is that it's permanent in many cases. Sometimes it's irrevocable, and the owner gives up a lot of control. For many people, trusts require the loss of too much control. So let's get back to the Hakimian estate and the agreement to arbitrate. The trial court, when presented with the estate's application to dismiss the action for an accounting, refused to enforce the provision in the will that any disputes regarding the interpretation of the will and the trust created under it or arising from the administration of the trust had to be settled through arbitration. The trial court denied the motion. The appellate court said there was no binding agreement to arbitrate. In addition, the mandatory arbitration was inconsistent with the authority that is given to courts generally to oversee the probate process. The issue is that if you and I agree to private arbitration, we are making a contract to replace the authority of a court to resolve our dispute with the authority of a private arbitrator. The arbitrator has the authority that the parties agree to. It's a matter of contract. The Hakimian will's arbitration clause, however, was not an agreement. It was an attempt to impose a condition on a gift that Mr. Hakimian was making unilaterally to his beneficiaries. There was no agreement, no contract, and the court would not force the parties to arbitrate. Co-executors tried to argue that there was an implied agreement to arbitrate based on the beneficiary's attempt to secure a benefit from the estate. This theory of an implied agreement is what's known as direct benefits estoppel. It implies the agreement to arbitrate by the fact that the beneficiary accepts the benefit of a contract that contains an agreement to arbitrate. There are cases in which this is a viable theory. However, the court rejected the argument here because Peter, the son, had not relied on the trust in a way that could require him to accept arbitration as the way that disputes would be resolved. The court said that an application to compel an accounting is actually not a dispute that falls within the scope of an arbitration clause. Any interested party can request an accounting under court rules, and the accounting proceeding is not inherently a dispute of the type that required arbitration under the agreement. The court also said that arbitration is contrary to the exclusive rights of courts to hear and determine all controversies regarding wills and trusts. Now, that line of reasoning has not often been seen by courts as an impediment to arbitration, but it was here. Does the reasoning here mean that an arbitration agreement in a will or trust document is never going to be enforced? Not necessarily. Attaching an arbitration requirement to a will is always going to be problematic because it's unilateral and there's just no mutual agreement required. But a will could contain a provision that places a condition on a bequest that the party either agree to private arbitration or forfeit a gift under the will. That's a different question. Most states hold that testators can give the gifts under any terms that they want as long as they don't violate public policy. There are some states in which an arbitration clause in a will has been enforced, and the concept has won some limited acceptance. In many states, the courts are unwilling to void the conditions for a gift in a will, except in rare circumstances. I personally think it would be possible to construct a will that makes acceptance of private arbitration to settle a dispute under the will a condition precedent to receiving any benefit. It's a condition on the gift, and in theory, it should work. In the case of a trust, it would be much easier to argue that there was implied acceptance of an agreement to arbitrate based on the actual receipt of benefits under the trust. In either case, clear advance notice, unambiguous language that is not overreaching, and some means to unambiguously confirm the consent of the beneficiary probably would all need to be present. It's a drafting approach that requires planning and care, but so far there are no court decisions that give any real clear guidance. In any event, thanks for listening. If you find the material useful or you think it might be useful to pass it on to someone else, please do so. And if you have a similar issue in your own life, you can reach out to me to discuss it. Thanks again.